So yes, IT Minister Ashwini Vaishnaw has tabled the Digital Personal Data Protection Bill in the Lok Sabha. The primary aim of this bill seems to be to enforce lawful and fair usage of online personal data. It also raises concerns of unfettered access to citizens' data by the government agencies. The draft version of this bill was first released by MeitY, the Ministry of Electronics, Information and Technology, back in November last year. After that, of course, it's gone through several rounds of consultations. Now we have this bill that proposes the establishment of the Data Protection Board of India, which is the DPBI. And the board's functions would include determining non-compliance with the law. That's going to be among its primary responsibilities. The board can also adopt what the bill calls urgent measures to curb data breaches. And the board can perform any other functions that are assigned to it by the government. That is what the bill says. How is all of this going to affect corporates? Would it really protect the rights of Indian citizens over their personal data? Before we delve into that discussion with our guests, here's a small report on the key highlights of this bill.
Nearly 6 years after the Supreme Court held privacy to be a fundamental right, the Digital Personal Data Protection Bill was tabled in Parliament today by IT Minister Ashwini Vaishnaw amidst opposition by parties like Congress, TMC and AIMIM. Remember, the bill will decide and set a regulatory framework for the data-reliant digital economy, all set to become a $1 trillion economy by 2030. So a law is crucial to decide how personal data of users is used by corporates, government and other intermediaries, whether inside the country or outside of it. And hence, the bill lays down some rights of users over their data while also specifying strict obligations for data fiduciaries, which collect and process personal data at a large scale. So what are some of the specific areas that the bill looks at? Number one, the definition of personal data. Number two, seeking consent of users before using their data, considering that most companies never ask us before they track us or they take our data. It also allows user consent to be withdrawn and their data to be erased. How is data processed within the territory of India and outside of the country is also one of the things that it looks at. Then there are stringent obligations for data fiduciaries on how third parties are engaged with them, while at the same time data fiduciaries have to maintain that safeguards are there so that data breaches can be avoided. In fact, in case of children, data fiduciaries must obtain the consent of parents. And most importantly, it allows for the formation of a data protection board to determine non-compliance and imposition of a penalty which could go as high as 250 crores in case of breaches. However, opposition parties oppose the introduction of the bill in the Parliament today, stating that it violates the basic fundamental right to privacy, including the dilution of the RTI. There's also excessive centralization of data, and that the Data Protection Board would act as a captive entity of the board and not as an independent regulation. However, the government maintains that the bill will give a framework to secure user data in the country as India moves forward on the path of building this decade as India's decade.
Can we create a decade as far as India's growth story is concerned is the question that we're asking on the basis of the contents of this bill, the provisions that have been made and proposed. And of course, this is in the Lok Sabha now. Let's discuss this. Manish Sehgal is partner at Deloitte India, and he's joining us on the show along with Aparajita, Bharti, the founding partner at TQH, the Quantum Hub, and of course, Arun, Prabhu, partner and head, Technology and Telecom at Cyril, Amarchand, Mangaldas, also with us tonight. Great to have you all with us. Arun, Prabhu, to you first. Why don't you begin by rating this bill's ability to protect personal data of Indian citizens and the kind of reasons that you ascribe to the kind of rating that you're giving it?
I'd rate it around 7 or 8 on 10. And the reason I have a range there is because some of this is yet to be written. There are parts of this bill which will be clarified in terms of delegated legislation which will come out. And so I'm giving it a little bit of a range to provide for that delta. The reason I say it is because it enshrines several fundamental data protection principles which are internationally recognized. Principles like storage limitation, principles like purpose limitation, principles like the requirement for clear, express, informed consent, the requirement for a clear consent notice, All of these factors, to my mind, make the bill a drastic improvement over the current state of play as far as the collection and storage of personal data in India is concerned.
Fair enough. Aparajita, do you believe that this bill and the provisions in this bill safeguard the personal information of Indian citizens? And also, of course, the infrastructure that would hold all that personal information. How would you rate it on these aspects?
I think, like Arun, I think I would also rate the bill around to be 6 to 7. I think in absence of this bill, we really have nothing that lays down the rights of data principles and protects those rights as well. So this is a good start. We've also had a very long consultative process in a very, very dynamic space because technology is constantly evolving as well. So I think a lot of thinking has gone into this bill. A lot of stakeholders have many different concerns. So this bill is trying to do a balancing act. So I think in terms of the rights of data principles, it probably has the rights, but in terms of implementation mechanisms, I think there are some improvements to be done. For example, the Data Protection Board itself will be appointed by the central government. And we don't know how independent that Data Protection Board would be. And when it comes to really implementing this law, this itself can become an issue. There are other things in the bill as well, which I do think that a lot of feedback was given, for example, around children's data. The age of consent is still 18 years of age, even though multiple rounds of consultation, stakeholders have highlighted that that will put Indian children at a disadvantage as compared to global standard. Those have not been taken into account. Having said that, I think some of the things like concerns of startups have been taken into account and specific clauses have been introduced that would enable exceptions for them.
Manish, Sehgal, do tell us about your reading of the provisions, because at this point in time, for the longest time, like our other two guests are pointing out, these discussions have gone on for a long period of time. Much of that discussion also hovered over localization of personal data. Now, this bill on data protection, it allows the transfer and storage of personal data in some countries, not those countries where the government has put strictures, of course. And yes, it does raise the penalty for violations. Has that part of that debate about localization of data found an adequate response in this piece of legislation as we see it?
Foremost, thank you so much, and Vikram, for having me here. It may not be absolute, and I don't think we should expect stars and moons on the day one.
Okay.
I think it's a great beginning for us to have. It's a great provision for us to have, and there can always be a way for us to improve. We have global experiences, learnings that can give the right direction, and the fact that it is no more a whitelisting and being proposed as a blacklisting, that means on the day one itself, enterprises won't have to look for a reason to stop. Now, so I think that's a very, very promising move, and the fact that end of the tunnel is seen from the viewpoint that the bill got tabled today, it itself is a very, very encouraging point. In terms of penalties, the way I look at it, I think penalties should be looked only as a way to avoid breaches and things to go wrong. It should not be the means for us to start working, right? So, that's the way we always talk about having a privacy-enabled enterprise rather than just a privacy-compliant enterprise. So you should not work only to ensure that you don't get breached, but I think its idea is to work in a manner that the enterprises have a DNA which promotes privacy and adherence of the personal data requirements. Those are my two thoughts, Vikram. Back to you.
Fair enough. Arun, Prabhu, perhaps we can take a step back. For someone who's an Indian citizen and is concerned about the kind of protection that personal data is able to be provided by my government, as far as the provisions of the bill that is proposed right now, which are the elements that should be of concern to me and what should put me at ease?
I'll start with the latter part first, because I think that's a longer list. As an Indian citizen, all data that relates to me, that is capable of identifying me or relates to me, is now protected. There's no multiple tiers of data. There's no sort of, oh, is this sensitive? Is this not? There's no multiple classification of it. To collect or process this data, all entities, whether they're sitting in India or they're sitting outside, which engage with me, need to take my informed consent by giving me a clear notice in any one of the 22 languages mentioned in the Indian Constitution. They need to make sure that I have in an informed manner consented to this data being collected and processed, they can only, even after getting my consent, they can only process it for the purposes which are, necessary and relevant. As soon as they're done processing it for that purpose, they have to go ahead and delete that data. If I don't like what they're doing, I can write to a grievance officer, or if it's a significant data fiduciary, to a data protection officer. If that data protection officer doesn't answer me within a time period that they will prescribe, I can go to a data protection board, and that data protection board can hand down fines as high as 250 crores, and for repeat offenders, actually block their access to Indian customers. This, to my mind, is a far stronger and heavily contrasted position from the position on the ground today, where at best I can maybe write to a body which has been largely defunct for many years, or go file a case before one of the high courts and sort of wait in line for a remedy. What should concern me, of course, is fundamentally that this still is a very, very consent and data subject centric regime. So you are your own stakeholder in this regime. You need to look at what happens to your data. You need to look at how it's collected, how it's processed. You need to write to people saying, what are you doing? Yes, you can use a consent manager to solve some of this, but it is upon you to protect your data. This bill merely gives you the tools.
Aparajita, the onus, like Arun Prabhu is pointing out, that lies on me as a citizen in protecting data. Do you think that we could have done better on that count, where I didn't have, as an Indian citizen, as much of an active role in doing so?
I think that's a really good question. And I think we've done a lot of thinking around this as a country, right? I mean, in the past versions of the bill, we had something called privacy by design, that all data fiduciaries had to undertake, their own privacy by design policy. But then I think the pushback from the industry was that this is very compliance heavy for startups, for smaller organizations. And now the data protection impact assessment only applies to significant data fiduciaries, which are of a certain size and scale. However, I do think that even with this bill, as Arun rightly pointed out, I think this is still the easy part that is getting done. The real part starts after this bill becomes a law, because now we need to educate our citizens as to how they can actually exercise their rights. And I think the government also is aware of that. And that is why if you actually see clauses related to notice in this current version, they actually specify that whenever consent is sought, the user has to be informed about their rights and also given information about the complaint mechanism. And if they want to complain, how can they do it? So I think just having this bill will only do half the job. Yes, we have a law now, but I think given that we are a low literacy society in terms of digital literacy, we really need to work on now getting this message out to citizens that they actually have these rights and this is how they can exercise them. I also want to say that, in EU, etc., apart from consent, there are other grounds for data processing too, such as legitimate purposes, etc., where they have actually put more responsibility on the platforms to be more privacy, privacy designed in some sense. We did not take that route because we also were trying to balance innovation and data privacy. But now that we've taken this consent-based route, I think we really need to do a lot, and the government needs to do a lot in also educating our citizens on how to exercise these rights.
Tell me, Manish, Sehgal, from what Aparajita is saying, as far as implementation is concerned, in the kind of education that must be imparted, because like we started out by saying, that the onus is going to be on us as Indian citizens to ensure that our data remains safe, and if there are any problems, that we raise our concerns. If that is the case, on one side you have the implementation battle. Also, as far as compliance is concerned, from all the fiduciaries, how many hurdles do you see coming through if this piece of legislation goes through?
Hurdles will be there, and I think we should accept that coming along. The hurdles would be from the fact that how to put this into a design. Right now, we just have a piece of paper. This has to have many implementations to take care of. And I think the most important point that Aparajita mentioned, I would like to echo that just putting the rights on a bill and getting them enacted is one thing. Letting the people know that these are the rights that they can exercise is another. To me, this is a bill or a potential act to protect the rights and the personal data of individuals like you and me. Now, if we don't know or we are not aware how to exercise them, then the job is half done. So it is not only going to have a hurdle about enterprises or data fiduciaries or significant data fiduciaries to have an ecosystem that can accept requests coming from people like you and me and to process it. But it is equally important that the people, individuals are aware under what circumstances, on what grounds, in what situations we can exercise those rights. So for me, this is a beginning. It's a long journey. As a civil society, we all will have to educate ourselves, and a lot of guidance, handholding will have to come from the right authorities, competent guidance, so that everybody, including individuals and enterprises, can embrace this change and we can work along in a handed manner.
Arun, Prabhu, do you think we have enough teeth for the Data Protection Board of India? Going by what you're reading right now, is this going to be the final authority, or do you think, in a way, it is only the government where the buck stops when we raise our concerns?
It's a bit of both. It's definitely, let me answer that question in parts. Are there teeth? Yes, there are, very significant ones. While the numbers which people are bandying around of 250 crores and so on are actually caps on fees, and there's obviously a whole list of factors that this authority has to take in, take into account while imposing these. They do have the ability to do so. And like I mentioned, they now have the ability as an innovation to recommend to the government that they block certain types of enterprises which have been found repeatedly to be in default of something from accessing Indian customers or offering goods or services in India. Second, there is an appellate mechanism which now goes to the TDSAT, which is a long-standing body, and from there, of course, on certain limited points, they can go up to the Supreme Court. But I just want to qualify here, of course, that our constitutional courts are not going anywhere. The High Courts and the Supreme Court of India continue to have the ability to review legislation and legislative action or executive action to check whether those are in consonance with the principles of privacy as laid down in the Puttaswamy judgment and so on and so forth. So to some degree, they also have a say, for instance, in whether the rules made under this are accurate, whether actions taken by this authority are fine, whether principles are fine, and so on and so forth. Lastly, perhaps most importantly, rule-making power on very crucial aspects, which may answer some of the points that Aparajita made, like, for instance, technical and organizational measures, reasonable security practices, all of which will be prescribed in rulemaking, and that rulemaking power remains with MeitY. So to my mind, this is an obligation that is spread across our constitutional courts, the TDSAT and the Data Protection Board, as well as the MeitY.
Indeed, but as far as these provisions are concerned, we were talking about how this is going to play out within corporate culture in India as well. Aparajita, when you're looking at these provisions and you see the newer laws that are getting made now in India, they tend to eliminate criminal penalties for non-compliance. Is that a good move that you see? Is this the kind of element that you see in the kind of legislation that we are now going to debate in the Lok Sabha?
I think, criminal penalties in bills which are basically looking at regulating industry, I think they are a big turn down for investors in India. And there has been a long-standing demand from industry to actually make them civil liability. So I do think that this is a step in the right direction. I do think that even without them, as Arun was also saying, there is enough teeth to this bill. And in fact, if you actually look at it, they have, in this version, they've actually introduced, which Arun also referred to, there is a DPB also has the authority to actually, block a service or block a data fiduciary if they are a repeat offender, which wasn't there in the earlier versions of the bill. So I think that actually is going to be a lot more effective. And in fact, to some extent, some experts have also said that that's disproportionate because even taking off a service can be to an extent, misused in certain situations. So ideally, it should only be for the same repeated offense. And there should be some nuance to it and not just any offense as it happens under many other legislations as well. So I do think that it's a good thing that the criminal liability clause has gone off from this bill.
Well, we are looking at possibly the growth of the entire sector, and how laws are framed is something that many who want to park money within this in different kind of ways are going to consider very closely. But talking of which, Manish Sehgal, this bill has extraterritorial coverage. It means that enterprises that are based outside India, serving persons in India, they will also be expected to adhere to the provisions of this bill once it's enacted, of course. So how easy is it going to be to implement that portion of this proposed law?
It is going to be implement easy or difficult, totally depends as to how the guidance is coming along. And to your last question, the point that you asked, that whether the board will have teeth, I would say that let's flip the coin and understand that how much of an enablement the board can offer. And I think that's one of the very, very critical part that the board will have to play to provide necessary guidance of making this law and the potential act on paper really get implementable. So for me, that is one of the great expectations, to make it easy to understand, to make it implementable. With respect to extraterritorial rights, thanks to European General Data Protection Regulation, this cross-border provisions or extraterritorial coverage has been in talk of the town over past 6 to 7 years, right? Ever since it has come into existence. So largely the organizations which have an MNC mandate, they are working across borders. They already are aware that the provision of this kind come, and hopefully they will already have mechanisms of addressing it. It is potentially for the first time that India would have something of that kind, of this nature, where the personal data being processed, stored outside India for the people like you and me in India is going to be spoken about. As long as the implementation, the guidance is being clarified, I think the implementation will be easy. Otherwise, there will be hurdles that we'll have to learn and work upon the way.
So bringing that parity is important in both domestic and players from outside the country. But Arun, when you're looking at this entire range of penalties that can be as high as 500 crore rupees, and that is going to be the same for NGOs and corporates alike when they fail to prevent data breaches. The legislation says it includes accidental disclosures, it includes sharing, altering or destroying personal data. So when you talk about that parity in penalties, and it's a moot point that is being brought up by the opposition as well, how do you view it?
I think you need to view it from a different lens. Whether you're an NGO, whether you're an individual, regardless of what you do, the question really here is, do you collect, store or process data? Now, if you do that, then what revenue you make from it or what potential earnings you make from it is completely irrelevant to the question of whether you have a duty to safeguard that data, and whether, as the bill requires, you have to follow reasonable security standards and practices which are proportionate in relation to that underlying data. Frankly, as a data subject, it doesn't matter if your data is lost by a corporate or your data is lost by an NGO. The point is your data is still lost. So fundamentally, I think the bill has the balance right on this. I think that regardless of the nature of the entity, penalties must be assessed. Of course, there are several criteria, like I mentioned, which are specified in the bill for the Data Protection Board to examine whether a breach has occurred. Is it willful? Is it not willful? Were reasonable security practices taken? Were technical and organizational measures taken? Did they notify people of the breach, as is the requirement under the bill? Did they take prompt corrective action? Did they do everything they could that they could safeguard data in view of how important it is and in view of their size and scale? Remember that you have to be a significant data fiduciary for some of the most difficult parts of this bill to apply to you. Now, if you are significant, either because of the size or the scale or the volume of the data that you process, or because you process it in a way which may have a massive impact on, say, electoral democracy, you should very well be subject to the highest and the most significant consequences under the bill, which include these penalties. So I'm actually fully aligned with that principle.
See exactly how this debate wears out, but of course we are going to be watching several elements and decoding several parts of this in days to come. Of course, India is growing into this larger and larger digital economy, and this legislation is going to cover its growth, and in that sense it becomes rather crucial. Manish Sehgal, Aparajita, Bharti and Arun, Prabhu. I know I've been struggling with Aparajita's name. I have to apologize for it. Thank you very much all for joining us on this edition of India Development Debate. And that debate, of course, carries on in the Lok Sabha. We'll continue to decode it. Thank you all for joining us tonight.